as well. So welcome everybody. Good to see you all. Hope you're all safe and well. This is obviously our second STC webinar. So today we're going to talk about force majeure and some other contractual issues with Natalie Ingram from EMW Law, who will take over in a moment. As I said, if there's any questions, please raise your hand virtually. You can also give us a little wave on the screen if you want. But let's keep the questions till the end and get Natalie chatting on that afterwards. So let her run through the presentation, then we'll do questions at the end. So I hope we're all okay with that. So obviously, as I said, this is the second in the series. So next week we've got another webinar with Barclays talking about the T-bills scheme to get like bridging loans and all that sort of stuff, which is a government initiative that they've put out. You know, that should be quite an interesting one as well. And I'm lining up several other ones as well, which we'll email you all about in a little bit later on. But also on the 14th, we've got a webinar with one of our ambassadors, Shai via Karnam, about sort of a checklist, sort of business strategy to get you through the current situation and things. And that should be quite a powerful one as well. So that's free as well, and you can register. There's details on the forum. We'll be emailing everybody as well. So make sure that you get into that. I think that's about it. I would now like to hand over to Natalie, who will obviously sort of talk us through the situation, and then we can do questions at the end. So over to you, Natalie.
Brilliant. Hi, everyone. Can you all hear me? Perfect. Thank you. So I've prepared a short presentation, hopefully not too long for you, just to go over some of the key points of force majeure. So I'll share that with you now. Here we are. Can you all see the screen that I'm sharing? Yeah. So we thought we'd do a quick presentation on force majeure, as it's one of the key topics that our clients are asking us about, and due to the current situation at the moment, a lot of people are looking to invoke force majeure clauses. So I thought we'd go through quite a high level discussion about force majeure, some of the key points as well. So just to give you a bit of background, the COVID-19 pandemic has heavily disrupted supply chains, and obviously now the contractual rights and obligations of contracts are heavily under scrutiny by ourselves and lawyers as well. So where contractual obligations are not fulfilled by parties, the other party may be able to bring a claim for damages for breach of contract. But if you have a force majeure clause in your contract, you can actually defeat that claim. So if you can rely on a force majeure clause, there is an excuse for non-performance there. So many businesses, in light of COVID-19, are now looking at whether they can rely on force majeure clauses in their contract. And now this is one of the most heavily talked about areas of commercial contracts at the moment. So what will this webinar cover? So I would want it really to be quite a high level presentation. We're not going into much case law or any particular detail, but I just really want to give a bit of awareness on what you need to look for if you are looking to invoke force majeure clauses. So we're going to be looking at what is force majeure. Is COVID-19 a force majeure event? Some considerations for you as well if you want to rely on force majeure. Processes to invoke force majeure. The remedies. What happens if there's no force majeure clause, which is a particular question that we're asked by clients. Give you some recommendations and top tips as well. And then we'll go over some of the frequently asked questions. And then if you have any further questions at the end, then we can go through those as well. So if we start with the basics, what is force majeure? So most commercial contracts now contain a force majeure clause. These are often found in the boilerplate provisions of a contract. So you might have seen these before. It typically excuses one or both parties from performance of the contract in some way. And on the occurrence of certain events which are outside a party's control, that party is excused from or entitled to suspend performance of all or part of its obligations. But unfortunately, there is no established meaning or consequences in English law. So it's not a standalone concept, unlike some jurisdictions, which makes it a little trickier to actually invoke in some ways. And it's heavily dependent then on the drafting of the contracts. So is COVID-19 a force majeure event? So as we've said, there is no there's no statutory or common law definition of force majeure, which means it is heavily dependent on the drafting of the clause itself. But there are a few adaptations of this and ways that solicitors have drafted these force majeure clauses in contracts. So we'll go through a couple of these just for something that you should look out for if you are examining your own force majeure clauses. So one is listing specific events. So sometimes a force majeure clause should have events specified in the clause, such as war, terrorism, earthquakes, and where the term epidemic or pandemic has been used, this will usually cover COVID-19 in our opinion. Acts of government as well, that's usually listed as a specific event. So where a government body has imposed travel restrictions, quarantines, or has closed buildings or borders, it's less clear when the government makes recommendations. And it's important when you're looking at your force majeure clause to see whether the list is exhaustive or non-exhaustive as well. And the second approach to actually defining force majeure in a clause is by setting out criteria. So you might have seen some of this drafting in your clause in your contract. So sometimes it states beyond the party's reasonable control. So this is determining whether it covers issues arising from COVID-19, and it's actually a matter of interpretation and is very fact specific as well. As you can see, obviously epidemic won't be detailed here, but if we say events beyond a party's reasonable control, looking at the situation and circumstances, we may be able to say that COVID-19 is covered here. Another instance is or any other causes beyond our control. Again, it can be very broadly interpreted, and it may still be triggered even if a health event or other relevant event is not specifically listed. That's another way of actually dealing with force majeure in a clause. And force majeure itself, you might have just seen that detailed in the clause, but it's not particularly common. Where it is used, it will be a matter of contractual interpretation again. But because just the words force majeure is used, sometimes it can be void for uncertainty. But it's definitely worth looking at the force majeure clause in your contract to actually determine whether COVID-19 would be covered as a force majeure event. In general, our opinion is that most force majeure clauses will cover COVID-19 as a force majeure event. But you need to bear in mind that just because a force majeure event has happened, it doesn't always mean that the parties will be protected from liability for failing to perform or a delay in performance. So you do need to look at the contractual drafting, but you also need to look at the situation and the circumstances that have led to this event as well, and actually what the party is stopped from doing. So what is it? What is the contractual obligation that the party is unable to perform? So what else needs to be considered? This is drawing from the last point there. So a party seeking to rely on a force majeure clause should consider the following things. Is COVID-19 within the force majeure events covered by the clause? That's probably the first thing to look at. If it isn't, is there more general wording which could include it? Does the event have to be tied to a specific obligation, or will it affect the contract generally? What happens if the clause is invoked? So, for example, if you have to suspend performance for a period of time, is there also the option to terminate? You also need to look at payments. You need to look at the consequences. What happens if you invoke this clause? And really that is, again, very contract specific, and every agreement will be different and cover this differently. You need to pay attention to the actual clause and how it's drafted. Does notice have to be given? So again, care is needed here, as some force majeure clauses require notice to be given, and also the requirement for notice to be given immediately. If you fail to do that, you might not be able to rely on force majeure clause. You need to check the notice provision in there. Do you have to mitigate the effects of the force majeure event? This is another point to consider. So, are you keeping proper records? That's one example. If there is a dispute about whether you can enforce force majeure, are you keeping proper records and evidence of the facts that you're relying on? Have you tried to source other alternative goods? How are you mitigating the risk then? Are there obligations you're required to comply with after invoking the clause? So are there information requirements, which is probably the most common one? And is performance prevented or hindered? Again, this will depend on the drafting. Some force majeure clauses say that performance only has to be prevented. Others say that performance is hindered. Now, what is the difference between that? So, for example, prevented, an example would be a supplier is unable to make the deliveries. So they physically cannot make those deliveries. Whereas hindered may be where the supplier has reduced or delayed deliveries. So they still are able to deliver, it's just reduced deliveries or delayed. There is a difference there, but it is down to interpretation and the drafting of the clause. So if a party wants to rely on a force majeure clause, what process must it follow? So there are procedural requirements under the contract which have got to be followed. For example, the requirement to give notice of its intention to rely on the clause to the other party within particular timescales, including any formalities required for the service of notices. Updates to be provided or an obligation to mitigate. So you need to make sure that these have been covered, and recent case law actually suggests that the courts take a fairly literalistic approach to this, so you need to make sure that you comply with it exactly. Remedies for force majeure can be excused from obligations or liability under the contract without damages being payable. An extension of time or termination in the event of continued delay or non-performance. A right of termination could be commercially important. That's always important to remember, as it may provide leverage to renegotiate commercial terms. So if you are in a situation where you think you might need to invoke the force majeure clause, you need to consider whether you actually want to terminate. You need to have that discussion. And this may be a way to actually renegotiate the contractual terms depending on the relationship with the party. So what happens if there is no force majeure clause? This is more a tricky one, and we're asked this by quite a few of our clients. So in the absence of a force majeure clause, there are actually two possibilities. So the first one is there is a breach. So in most cases, the party that cannot perform its contractual obligations is in breach of contract. This isn't ideal, which is why we would rely on a force majeure clause. In this instance, if there has been a breach, the other party can claim damages and may have the right to terminate the contract. And the second one is frustration. So rarely, if a contract's frustrated, it's because performance has become physically or legally impossible. The contract would automatically end without any action by either party, so there's no need to comply with notice requirements. The contract does just come to an end. But again, this will go on to frustration very briefly, but frustration is actually very difficult to prove, and there is a very high threshold for that, as we'll see shortly. So frustration, like I say, we'll touch on this briefly, but it's very difficult to show that frustration has actually happened and that the contract has been successfully frustrated. The threshold is very high, and the test is actually really quite strict. So a contract can be frustrated when a frustrating event occurs after the contract has been formed. The event is beyond what was contemplated by the parties. Neither party is at fault, so again, it's similar to force majeure in that way, or the event renders the performance of the contract impossible, illegal, or radically different from what was contemplated by the parties at the time. So the fact that performance has been made more difficult or costly isn't going to be enough to frustrate the contract, unfortunately. The doctrine of frustration allows a contract to be discharged when an unforeseen event occurs that renders the performance of the contract impossible. So unfortunately, you can't rely on the doctrine of frustration if it's just a bit more difficult or costly to perform those obligations under the contract. Usually where a contract contains a force majeure clause, you can't rely on frustration. And the reason for that is because force majeure has already been considered in the force majeure clause, obviously. So events that would mean impossible to perform has already been catered for elsewhere in the contractual provisions. So you then have to rely on the force majeure clause rather than frustration there. But like I say, frustration, it has a very high threshold, and it's very rare that actually a contract is frustrated. But given the current situation, we might see that more contracts are frustrated if there is no force majeure clause available to the parties. If the force majeure clause isn't full, complete, or specific enough, it may also be possible to invoke frustration as well. So just as a word of warning, force majeure clauses should only really be invoked in extreme circumstances, and the same with the doctrine of frustration as well. So they're deliberately intended to be invoked only in these extreme circumstances. It's not to be taken lightly. If you terminate the agreement when you're not allowed to, then it can actually be wrongful termination, which may entitle the other party to bring a claim against you for its losses, so the damages. You should also consider the impact on future business relationships as well. So how is this really going to affect your relationship with the other party if you choose to invoke a force majeure clause? What's going to happen in the long term? These are all things that really do need to be considered before invoking the force majeure clause. So we put together a few recommendations just to go through that might help you if you're thinking of looking at your force majeure clauses in your contract. So you should always review the force majeure clause very carefully. So you need to look at the precise wording of the force majeure clause, the contract as a whole, and the circumstances. It can be pretty tricky to determine whether force majeure applies in some situations, as it's broadly down to interpretation, and it can be highly fact sensitive as well. So unfortunately, there's no generic answers for how force majeure actually applies. Each agreement will be different, and the drafting is obviously very important to determining whether the force majeure clause has actually arisen and whether it can be invoked. So you should review the rest of the terms of your contract as well to understand your rights and obligations and allow you to scenario plan accordingly. So you might have other responsibilities under the contract. So an example of this would be the business continuity plans, or you might have the right to terminate or alter price regardless of force majeure. So force majeure really should be the last resort, if you like. And like I mentioned earlier, it should really just be invoked in extreme situations when there isn't really another alternative. So have a look at the other terms to understand whether there are any other options available to you, or whether you are going to have to invoke that force majeure clause. Consider whether there are any other ways of performing, reducing delay, or minimising any loss to the other party. This is quite important. So you need to look at ways that you can perform your obligations under the contracts. So if that means considering alternative suppliers, alternative methods of delivery, even at a higher cost. Obviously, we'll be looking at what's reasonable there. But if there are any other ways of performing the obligations, then those should really be considered properly before invoking the force majeure clause. You need to, of course, serve notices as required under the contract, which I mentioned previously. It's really important that the notice requirement is complied with, and to the letter as well. Got some further recommendations. So increased costs probably it's probably not going to be enough to excuse non-performance or delay. And if the contract doesn't contain a force majeure clause, consider frustration, but again, be aware that there is this really high threshold for determining whether a contract has been frustrated. Have a think about alternate ways you can perform your contracts, or perform your obligations, sorry, as mentioned before. But there is also, if you need to agree other ways in performing them, then you may need to vary the contracts. If it's a variation of the contractual terms that are there, you need to make sure that you enter into a legally binding variation to the contracts. So if you have a conversation with the other party and you're negotiating ways around this, how to get through this pandemic, then you need to vary the contract, and you need to check the variation clause in the contract as well there to make sure that you can vary the contract and also comply with the legal requirements for variations as well. So we'll go through some frequently asked questions. So we've had an influx of questions from clients recently on this. So we've put together a few of the most frequently asked ones. So the first one, why don't all contracts include a force majeure clause? So it seems like a very simple question, but not all contracts actually contain force majeure clauses. So the contract may deal elsewhere with the risk of performance being impossible. So for example, there may be some really extensive disaster recovery provisions in your contract. So it's worth having a look at the contract to see whether there are alternate options there. But it's not really as common in some contracts with little risk of unforeseen changes preventing performance, or short-term contracts, or low-risk contracts actually, including force majeure clauses. They're more commonly seen in long-term, high-value, and also, of course, it depends on the circumstances there as to whether a force majeure clause would really benefit the parties, and also the risk of a force majeure event actually happening or preventing performance. So it's not in all of the contracts, but given the situation that's happening now, I think force majeure clauses are going to come under scrutiny a lot more, and the drafting is definitely going to play a bigger part in the negotiations of a contract. Is COVID-19 now considered a foreseeable event, and can we rely on force majeure clauses in contracts that have recently been entered into? So this is quite a common question as well that we're finding that clients are asking, because force majeure clauses in general say that it has to be an unforeseeable event, obviously depending on the drafting. But now we're all aware of COVID-19, is it a foreseeable event, and can you rely on force majeure clauses that you've recently entered into? So, I mean, taking just a practical approach, it probably, well, it certainly wasn't anticipated that COVID-19 would arise when you were entering into contracts back in January 2020 in England. Whereas if you're entering into contracts now or mid-March 2020, it's going to be a lot more difficult to claim that COVID-19 issues weren't anticipated. So we knew about this, and it's reasonable to expect that this was anticipated. So relief for force majeure might not be available in contracts that you've entered into recently. But again, it depends heavily on the wording of the clause. Should COVID-19 be specifically addressed in force majeure clauses going forward? So this leads on from the previous question. If you're entering into a new contract, you should really consider whether to include express wording to deal with the impacts of COVID-19. So again, like I say, I think going forwards, we're going to have a lot more, there's going to be a lot more scrutiny on the drafting of these clauses, and you can expect that they're probably going to become a lot more lengthy and cover a lot more events as well. So including epidemic or similar as a force majeure event in a new contract may not actually be sufficient where the risk of COVID-19 was already in prospect. So that's just going on from the previous point. Many force majeure clauses will expressly state that the event must not be foreseeable. So again, is the event foreseeable? If it is, then we need to include some drafting in the clause to deal with that. Should COVID-19 be specifically, in those circumstances, you will need to include alternate wording to allocate for the risk of COVID-19, as I've just said. Can we pass increased costs on to our customers? That's another question that we're faced with quite regularly. Again, this is heavily dependent on the terms of the contract. So the contractual provisions need to be reviewed and consider the position if there was no force majeure clause. So if the price is fixed in the contract, then it's unlikely that the supplier is going to be able to pass any increased costs on to customers. But if there might be a force majeure clause in the contract, and in the case of a force majeure clause, normally each party is responsible for its own costs. But sometimes the force majeure provisions may specify whether you can pass on the extra costs and expenses as a result of the force majeure to the customer. Again, this is really dependent on the drafting, and it is quite unusual to have that included in there. But going forward, we might see a change in the drafting there. An increase in costs is really unlikely to allow for force majeure, unless, of course, the clause specifically states this. So it's unlikely that you'll be able to rely on frustration of the contract either. What happens if we have business interruption insurance? So this is quite a common question asked by our clients as well. So business interruption insurance is intended to cover losses resulting from interruptions to a business's operations. And it's really important that companies actually assess the specific terms of their insurance policies. COVID-19 might be covered, but again, this is going to be really dependent on the terms of the individual insurance policy. But if the insurance policy covers this, you may be able to rely on business interruption insurance. So it's worthwhile checking out your insurance policy if you have one. How important is the governing law clause in relation to force majeure? This is really important if you have an international contract and the law isn't the law of England and Wales. So when considering whether a force majeure event has occurred or whether you can invoke a force majeure clause, the governing law clause in the contract must be checked. Other jurisdictions don't actually follow the same approach as we do in England. So it's going to have an impact on whether a force majeure event has actually occurred, even if it isn't covered by the contract. So in some jurisdictions, there doesn't need to be a force majeure clause in there, and force majeure is recognised by law in other jurisdictions. So it's definitely worthwhile checking what law applies to your contract. I'm presuming a lot of contract that you'll be looking at, the law is England and Wales. But if you are dealing with different jurisdictions, there may be a different governing law in there. So it's worthwhile checking that out. If a contract becomes uneconomical to perform, can the party rely on force majeure? This is another question that comes up quite frequently. And the answer is probably no to this. And the reason being that in the past as well, there is case law that suggests that even a severe downturn doesn't amount to a force majeure event. There is a difference between the inability to perform and inconvenience. So you really need to assess if somebody is serving you with a force majeure notice, if they're wanting to invoke the force majeure clause, you need to assess whether it's inability to perform or an inconvenience. The contract should include a separate clause to deal with changes in market conditions. So we frequently add in clauses to contracts which deal with this, the availability of credit and price fluctuation as well. So if you are looking to sort of alter prices and whatnot, then you need to look for contractual provisions in the contract that deal with this specifically. Force majeure probably isn't the clause that you need to be looking at. And in some instances as well, events are expressly excluded from the definition of the force majeure event. So it's important to consider the drafting. If the government has made a business close its factory, It cannot manufacture and meet its obligations to supply to customers. Can the manufacturer rely on force majeure? If the factory is the only means of manufacturing, then it's likely to be a force majeure event. You need to check the contract for notice requirements and consequences of force majeure, as we've gone through today. But if there isn't a force majeure clause and the factory is the only means of manufacturing goods, the contract may have been frustrated. So if you don't have that force majeure clause in there, the contract may have been frustrated, as there is an inability to perform the contract. It's impossible. If there are other ways the business can manufacture, though, it's unlikely that the requirements of the force majeure clause or doctrine of frustration will be satisfied. So, for example, do you have other factories in other areas which haven't been closed down and aren't subject to the same rules? Can you still manufacture from them? Is it possible to manufacture elsewhere, rent other premises, etc.? We'll be looking at what's reasonable there, though. So that's something to consider. Another question is, sales have dropped and the business wants to cancel orders it's placed with its suppliers. Can the customer rely on force majeure? So the customer should review the contractual terms to see if there's a right to cancel orders regardless of force majeure. There might be a contractual provision in there which allows you to cancel orders. You would need to specifically look at the clauses in there to check whether you have the rights to do so. Unless the force majeure clause specifically addresses a decline in sales, it's really unlikely that this will constitute force majeure. The difference here is that this is inconvenience. As we mentioned before, it's really important to distinguish an inability to perform, so it's impossible to perform your obligations under the contract, and then just an inconvenience. So frustration wouldn't be available here, as performance is not impossible. And again, this question relates to the increase in demand for certain products. So, for example, healthcare products, there's been a complete increase in demand for these over the last few weeks and what might be months. So if the business experiences an increase in demand for the product and there are various volume-related incentive mechanisms in the contracts, can force majeure be used to remove those mechanisms? And the answer to that is no, it's very, very unlikely. So force majeure clauses are not drafted or intended for this use. Frustration is very unlikely to apply, as there's no issue of radical difference or impossibility of performance either. The the obligations are still being performed. It's just an inconvenience, or they just would like, for example, the rebates to be deferred. And that's the end there. So if you have any questions, please ask.
I would like to kick off, if I may. It seems to me that the government wording in this is really important, because from Make UK we hear that the government has actually specifically told that they haven't told manufacturing companies to close down and stop anything. So presumably, whether or not they declare something as law or whether they make a recommendation or issue advice is a massive play in this, isn't it?
It is correct. So it's really going to be dependent on whether the government has told them to stop manufacturing and things like that, and whether you're following specific rules in place. It's a very grey area at the moment, because a lot of businesses are trying to invoke force majeure clauses, and we don't have any case law in this instance to sort of back it up, if you like. No doubt there will be a lot of disputes over whether a party can actually invoke a force majeure clause, because it is a lot down to interpretation, and it really will depend on the drafting of that clause. Some contracts include force majeure clauses which are extremely lengthy. Others go for an extremely short form force majeure clause. So it will really depend on whether that clause can be invoked. And if there isn't a force majeure clause, like we say, if there's a complete inability to perform the obligations, it's impossible to perform them, then the contract may be frustrated. But realistically, that might not help some manufacturers who actually want to do business with these customers after this event has happened.
And if I may, because I think quite a few people on this call will be suppliers to sort of larger organizations. If they sort of come back and saying, look, you know, we had a contract for X amount of your parts, but they have to go in our product. We don't anticipate being able to sell our products now, so we don't need them anymore. Thank you very much. The end. Do you have any recourse to that? I mean, how do you deal with that? Because I should imagine that a number of our guys might be in a situation like that. I mean,
yeah,
obviously depends on the contract, but
of course, that's what I was just about to say, Pim. So it's heavily dependent on what contractual provisions are in there. You should really seek advice or review your own contract thoroughly, not just the force majeure clause, to see what recourse you have, to see what happens in terms of purchase orders. If somebody's trying to reject the goods that haven't yet been delivered, are they able to do so? Are they actually able to invoke the force majeure clause? It is all down to interpretation, and unfortunately it is down to the drafting as well. And it's a really tricky grey area.
Right. I'm actually unmuting everybody in case there's anybody who wants to ask a question or raise hand. Anybody?
Could we have your contact details, Natalie, please?
Yeah, of course. Yeah, I will. I can give them to you now, or I can get Pim to send me an email.
What we'll do at the end of this call, we'll send out an email to everybody, which includes the recording of this, but we'll also include some details from Natalie if you have any follow-up questions or anything like that.
Superb.
Yeah.
Thank you.
Brilliant. And if you have any other questions on issues that you're faced with as well, that isn't just force majeure, just let me know, and I'm happy to chat through it with you over the phone as well. Because I appreciate a lot of it is very specific, and it's all in the detail of the contract, which isn't too helpful on a webinar such as this, but hopefully I've given you some key pointers to look at and to go away with. And it's really important to bear in mind that you need to look at the whole contract and the circumstances surrounding that as well. But yeah, more than happy to chat to you about it.
Does anybody have any other questions?
Well, I've got a slightly weird one, because working in marketing, but probably the question I've got is concerning media. I don't have a force majeure clause with any of my clients, I don't think. However, if I've booked on behalf of a client some advertising space in, let's say, a magazine that has got a force majeure clause, and they decide that they're not going to publish a particular month when my client's ad should appear, how does that affect me with regard to the client? If the client says, hang on, Jeff, that ad hasn't appeared and we really wanted it to appear, and we were counting on it, where do I stand?
Right, so you haven't got any force majeure clauses in your contract, but
no.
Presumably then you're totally reliant on the other party performing their end of the deal, if you like, so the marketing space or advertising space. So you would need to. How have you gone about this so far, Jeff? How have you?
But it's not arisen, and I don't suppose it will arise.
Yeah, that's a really tricky one. It is tricky because usually we'd see that it's sort of back to back. So, for example, if you aren't able to perform due to, obviously it's beyond your reasonable control, but if the marketing space isn't available, you aren't able to perform your part of your contract with your client either. It is a tricky one. You would need to review the rest of the terms of the contract, see what your recourses would be there. Otherwise, you're going to be in breach of the contract with the client.
Yeah, I'm sure. I mean, I hadn't even thought about it until I came to this seminar, and it's likely not going to happen because we've managed to cancel most of the space that we booked anyway. And there's been no problem, and nobody has mentioned on the media side had mentioned taking any action because we didn't fulfill a contract as such.
Yeah, I think where it becomes tricky is if you've already paid for that service. So if your client has already paid you to accommodate for that marketing space or advertising space or whatever it is that you're supplying, it's difficult if they've already paid you for that. That's where it becomes a little bit more muddied water.
Yeah, but okay.
And I suppose if you extend that as well, because if you're a supplier to somebody else, but then and you're able to perform, and that's fine, and they still want the products, and that's all fine. But we do see with a number of companies that their supply chains are drying up because maybe some of their suppliers are unable to perform, and so you might actually be put in a position where you can't fulfill your contractual obligations because one of your suppliers is letting you down. And that must be kind of a tricky situation as well, because that will impact upon your contract with ultimately your customer, wouldn't it?
Yeah, so it seems like there's going to be a knock-on effect down the supply chain, basically, which is going to cause a lot of problems for so many businesses. But unfortunately, it is down to the contractual obligations, otherwise you are going to be in breach. And that's why it's so important, really, when you're looking to sort of back-to-back the obligations and make sure that it's catered for. I mean, I think going forward, people are going to have these situations in mind when they're negotiating and drafting a contract. But before, possibly, these situations weren't necessarily considered to this extent. But it is a tricky one. But you should look at what your obligations are to your customer. Obviously, the circumstances surrounding that as well, where the payment has already been made to you. And we're finding actually when we're advising clients, the best thing to do is just pick up the phone. A lot of people are being quite lenient with deferring payments or postponing certain obligations. So even without a force majeure clause in there, we are seeing quite a lot of understanding from a lot of businesses. Businesses want to get through this, and long term, it's not always the best solution for everything to terminate.
Excellent. Was there any other questions of anybody else?
Natalie, hi. Just a quick one from us. We've got obviously our quote terms and conditions and purchase order terms and conditions from our customers. I'm just looking at one particular example. Our force majeure term includes performance of obligations except for non-payment of amounts that are due. Customer force majeure term includes all obligations. So if they choose to not pay because their finance team is currently isolated, and we need to chase the payment.
Yep.
Do we have a leg to stand on, or does it just simply become a bouncing match?
Yeah, so I'd need to look at the detail of the contract and the specific wording. But like you say, sometimes payment obligations are actually carved out from force majeure. So like you say, there are often cases where force majeure, the force majeure clause says all obligations are suspended except for payment obligations. So in that case, you would still be able to request the payment from the client. So they wouldn't be excused from that obligation. It's been specifically carved out in the contract. Yeah,
but presumably it comes back to the usual problem of they've accepted our terms by issuing a purchase order, and we've accepted their terms by working on it, at which point it comes down to whose lawyers are most expensive.
Yeah, it's going to be the battle of the forms. Whose terms and conditions supersede the others? Who was the last one to provide their terms and conditions and agree to those? So it might be a bit of a bouncing match there. Yeah, might be going back and forth on that one. If your terms are completely different to theirs, and obviously you've carved out payment obligations, theirs haven't, whose terms apply? Yeah. And that will be a matter of the situation. Yeah, it will be down to the circumstances there.
Yeah, and ours are English law, and there's a Chennai court. So it'll be interesting.
Yeah.
Thank you very much.
Excellent. Was there any other questions from anybody? Doesn't look like it, right? So I think we'll leave it there then, but thank you very much, Natalie. I think that's been quite helpful. As I said, we'll send out an email to everybody with a recording of that. We'll share Natalie's contact details as well. If you had any follow-up questions, I'm sure Natalie will be happy to address them. You know, I'm sure she's available to do work for you guys as well, should that be needed, clearly. Yeah, thank you very much for attending. I hope you find it of use. As I said before, you know, this is part of a series. So next week we'll have one on the C-bills scheme for the business loans by government. That'll be run by John Corbett from Barclays. So do make sure that you're part of that. And also, as I said, Shaibi Akarnam is running a seminar on the 14th, all to do with sort of business continuity planning, and really it's kind of like a 100-day, 1,000-day program on, you know, what you should be doing over the next 100 days to make sure you're still around to complete the 1,000 days. So both of those I think are going to be quite interesting. As I said, we're planning a lot more, so we'll inform you on all of those as well. So do, you know, look out on the STC member forum, but we'll email people as well. And so yeah, hopefully we can keep you informed and provide you with valuable resources to navigate through all of this. But we'll leave it there. Thank you very much for joining, and I hope you all have good days, and obviously stay safe and healthy. And thank you all very much.
Thank you, Pim. Thank you, Natalie. All the best.
Have a good weekend.
Bye.
Thank you.